Hi, this is Keena Kim with PivotalDiscovery.com, and we're here at ILTA09 with Allison Brecher, who is the Senior Litigation Counsel and e-Discovery Coordinator with Marsh McLennan. And Allison is going to share some of her thoughts today on cloud computing and social media. Allison?
Sure. Well, one of the big challenges in e-discovery when we implement legal holds is it's hard enough to identify the relevant employees or the former employees of your company that may have documents. It's a whole other thing to try and identify what non-party witnesses might have documents relevant to your litigation matter. Under the law, we all know that we're responsible for, at a minimum, notifying those third parties who are under our control, like subcontractors, independent contractors, of the legal hold notice. In my opinion, I think you're also responsible potentially for notifying any kind of social networking providers where documents may be stored. This really comes up, in my experience, most often in the employment context, where someone is job seeking, or maybe they've claimed disability and maybe have made a medical type claim, and suddenly you find pictures of them hiking on their Facebook page. So obviously those are the kind of things that you want to look out for. It may require a subpoena to be sent to that, to the Facebook or LinkedIn or whatever particular social networking provider. It might also be something a little more primitive, like just simply copying the person's profile page, sticking it on a CD, and putting it aside as part of your document preservation efforts. Or it may also require, of course, cooperation from the individual employee or former employee to actually do that as well. So some companies, I think, are more and more either starting to have a social networking policy that either allows company information to be stored on those sites, or at a minimum gives the company control so that if it's required during litigation and as part of a legal hold, we won't have difficulty getting cooperation from employees around securing data on those sites. I think an argument can be made that data on those sites is so-called not reasonably accessible because you have to request employee cooperation, and Facebook, of course, is not under the organization's custody, care, or control. I think that's another argument that can be made. Likewise, with cloud computing, with more and more companies using software as a service where employees have access to data that's maintained by some other provider, the same analysis would really apply. At a minimum, I think you've got to send them the legal hold notice, or at least advise them of the litigation and let that organization do what it sees fit. Hopefully your contract with that company addresses that issue. If not, it's something to consider putting into your contracts. But it just adds another layer to the e-discovery process and to your document preservation protocol.
Great. Thanks for sharing that with us, Allison.
Sure, my pleasure.